New York State is in uncharted waters now that recreational cannabis use for adults is legal. Can you be drug tested by your employer for consuming cannabis at home?
And is it any of their business? As the News 4 Investigates team discovered, companies are now grappling with these questions. Luke Moretti reports.
This is all untested waters.
Challenges over whether someone shows up to work impaired are inevitable. Legal experts tell News 4 Investigates.
How do you figure out impairment?
That's something employers are grappling with, because even a positive test result doesn't prove someone is impaired in the moment. Cannabis can linger in the system for weeks, even after non-use.
Unless somebody comes into work either carrying cannabis or otherwise, are showing articulable and visible signs of impairment, then an employer is not free to do what they want.
State Labor Department guidance has been issued. Employers are in the process of digesting it and implementing policy changes as needed.
Employers can't take actions against an employee for their legal off-duty conduct. What happens at home can't impact your workplace.
According to state guidance, a break or meal period means you're still on the job, so you can't do it. And even if impairment on the job is suspected by an employer, that can be tricky. Lisa Casa is an attorney specializing in labor law.
A drug test on its own isn't going to necessarily tell you if someone's impaired. And that's the restriction. Someone can't come to work impaired. So it's very difficult for employers to tell it. So, that's another layer, is how do you figure out impairment?
At the federal level, marijuana is still illegal. So if you're federally employed or regulated, how do you deal with the conflict in federal and state laws? Attorney David Holland specializes in cannabis-related workplace issues.
People that have commercial drive-in licenses and things like that are regulated, particularly they're issued by the federal government and Department of Transportation, they have an obligation to drug test because it's still federally illegal. And so therefore discipline could be taken against them.
At the state level, guidance is clear that employers cannot discriminate against employees for using cannabis in accordance with state law. But it also spells out permitted employer actions that can be taken. For example, when there's a state or federal statute, requirement, or mandate, if the employer would be in violation of federal law or would lose a federal contract, if the employee, while on the job, shows articulable symptoms of cannabis impairment that lessen performance or interfere with a safe and healthy workplace.
Really got to be shown to be unsafe and incapable of performing the duties of their job at that given moment before it can be a viable complaint by an employer to take action against an employee.
We get questions pretty much on a daily basis now about this topic.
Liz Warren is Executive Vice President and Chief People Officer with Employer Services Corporation in Amherst. The firm works with hundreds of companies on workplace compliance and policy matters.
What do you see as the biggest challenge going forward with this?
I think the biggest challenge is how to know if you're seeing symptoms that are on this reasonable suspicion checklist that you should send someone for a drug test. And it's tough, right? Because if it's alcohol, it's pretty clear. If someone's exhibiting symptoms and they have an alcohol test and it's positive, you know it was used recently. Not the same for cannabis.
A report done for the National Safety Council, which surveyed employees nationwide, found that about 35% said they observed cannabis use during work hours. The report notes that the construction industry saw this behavior significantly more often than those working in other industries.
So it's a real challenge.
The National Safety Council's Katie Mueller tells News 4 Investigates that what came through loud and clear in the report, employees want employers to talk to them about cannabis use.
They want to have policies that support their ability to work or their ability to keep their workplace free of impairment. And so I think that that was one of the huge takeaways for us at the National Safety Council.
In addition to recreational use, certified patients in New York State can use medical cannabis if they suffer with a debilitating or life-threatening condition. Under state law, they have even broader protection from any adverse employer action, according to legal experts. Luke Moretti, News 4.